This is how to write a killer answer to a debt collection lawsuit just like a real lawyer would. Watch closely, because if you know how to do this in the right way, you're going to vastly improve your chances of winning your lawsuit. But if you get this wrong, you might accidentally admit facts that kill your case or even give up the right to defend altogether. And stay with me through the end, because I'm going to tell you about one critical mistake that most people don't expect. And if you get this wrong, you could be sending your case on a fast track to doom. My name is Michael Wasik. I'm one of the lawyers at Ricardo and Wasik here in Florida. And together with my partner, Jason Ricardo, when debt collectors give you hell, we help you give it back. Debt collectors file thousands of lawsuits every year trying to collect money from people in Florida. And if you've ever gotten that knock on the door with a process server handing you a summons and telling you you've been sued, then you know that sinking feeling in the pit of your stomach. And then you have to wonder what comes next. How do I respond? How do I make sure not to screw this up? How do I make sure to avoid having a judgment entered against me, avoid having my wages garnished, avoid having debt collectors seize bank accounts, seize property, seize vehicles, and all that other unpleasantness that comes with being sued by a debt collector? And we've been to court on these cases all the time, and we see hundreds, if not thousands of people make the mistake of not responding to the complaint at all. They ignore the case and pretend it's going to go away, and that results in a default judgment, and then they're surprised when they get a garnishment notice from their employer. That's why it's so important to know how to respond, because if you don't do this right, you could end up being in that situation where suddenly you're missing 25% of your take-home pay because you didn't know how to respond properly to a debt collection lawsuit. Now, here in Florida, there are two types of cases that debt collectors routinely file. First are the small claims lawsuits. Those have special rules and special procedures designed to streamline the process. And the second type of lawsuit that gets filed are the ones under the regular rules in either county court or civil court. And those are for amounts that are typically over $8,000 and therefore don't qualify for the small claims rules. And when you're responding to a small claims lawsuit as opposed to one under the regular rules, you need to understand that the response required of you is going to be different. So the first step, the most important step in any response to a debt collection lawsuit, is to read the documents you've gotten. The summons that you are handed will give you instructions about how you need to respond. And in Florida, there's two ways that your response is going to be required. So in Florida, under small claims rules, you're going to have to respond by appearing at a court hearing at a particular date and time. And you may have to appear in person, you may be able to do it over video, but those instructions are going to be in the summons itself. You must read the summons and understand if you need to appear at a court hearing at a particular date and time. Now, if your case is under the regular rules in county and civil court, then you're going to have to file a written response to the complaint within a set period of time, usually 20 days. If you fail to file that response, then you are going to lose your case by default and having a default judgment entered against you. And if you have a default judgment entered against you, you're going to be exposed to collection efforts that could include having your wages garnished, having your bank account seized, or other assets taken from you. So you definitely want to avoid that. That's why it's incredibly important to read the summons in detail and understand whether you need to appear at a court hearing or whether you need to file a written response. If you need to appear at a court hearing, we're not covering that topic in today's video. Instead, you should leave a comment below and let us know if you're in Florida and need help responding to a small claims lawsuit. That's something that we can talk to you about. But if you need to file a written response, I'm going to walk you through the steps that we take in order to prepare that response, and you can follow along on your own. The first step in preparing a response to a debt collection lawsuit is to understand your theory of the case. Why is it that you deserve to win? Why is it that you should win? And there are a lot of different reasons why this might be. It might not be your debt. You might be the victim of identity theft or mistaken identity. It might be a situation where the amount they're claiming is wrong or you've already paid it off. It might be a situation where the people on the other side don't have the right to sue you because they don't actually own the loan. Maybe you're just at a stage where you haven't seen any proof that you actually owe money to these people and you want to exercise your right to make them prove their case. Now, once you've decided on your theory of why you deserve to win, that's when you go to the next step. Take the complaint or the statement of claim and read through it carefully, step by step. The complaint against you will have several numbered paragraphs. You're going to want to break out a separate piece of paper and write down for each numbered paragraph whether you admit the allegation, deny the allegation, or maybe admit it in part and deny it in part. And I'm going to walk you through the steps of how to do that. For every allegation they make against you, you'll want to understand how it relates to your theory of the case. So for example, if your theory is identity theft, meaning somebody else has stolen your identity and run up charges without authorization on your bill, then you're going to want to look for allegations that say that you are the person that benefited from the debt. You're the one that supposedly ran up these charges, and you're going to want to keep that in mind as you decide to admit or deny. A complaint is supposed to allege facts that relate to the case. And so for each fact that is alleged, you're going to decide whether to admit that fact or deny that fact. And if there are multiple facts alleged in a single paragraph, then you may want to admit some facts and deny others. And here's my general approach. Unless I'm 100% certain that a fact is true, I'm generally going to deny it and ask the other side to prove it. Because if they're alleging it, it's usually because that's part of the case that they have to prove. And if they fail to prove any part of their case, then you will win. So for example, the lawsuit might say, the defendant's name is John Smith, who is over the age of 18 and lives in Florida. Now that's 3 different facts, but if your name is John Smith, you're over the age of 18 and you live in the state of Florida, you'll probably just want to admit that. But if any of those 3 facts aren't true, you'll want to deny the one that's not and admit the others. But what if it's a fact you're not sure of? So for example, they might say they mailed you something on a particular date. Well, if you never got it, you don't know if they mailed it. So for a fact like that, you might want to simply deny it or deny it for lack of knowledge. Either one works just fine. Now, what happens if they allege something that's really not a fact, but more of a legal theory or a legal statement? So for example, they might say that John Smith breached the contract. The idea of breach and whether a breach occurred is a legal conclusion that depends on the application of the law to particular facts. Now, what we do when a complaint just alleges some kind of legal theory, we'll often deny that because it calls for a legal conclusion. So if you've got an allegation that seems like it's calling for a legal conclusion, you can go ahead and deny it on that basis and you'll be just fine. You'll want to do that for each of the numbered paragraphs in the complaint that states an allegation against you. You'll want to admit it, deny it, admit in part, deny for lack of knowledge, or deny because it calls for a legal conclusion. Once you've gotten to the end, then we move to the next step, deciding on your affirmative defenses. An affirmative defense is some fact or set of facts that if you prove them, then you get a legal excuse for whatever they've accused you of. So if you raise a statute of limitations defense and you prove that too much time has passed, even if you owe the debt, even if they've got you dead to rights, even if they've got everything documented, you can still win the case because the law says that if too much time has passed, they sat on their rights, they've given up the right to sue you, and the case should be dismissed. So that's an example of an affirmative defense that if you prove it, you can win. There's 2 things to think about when you're choosing affirmative defenses. Number 1, there are things that you're going to have the burden of proving. So in the statute of limitations example, you're going to have the burden of proving when the debt arose and how long it's been and how long they waited and sat on their rights before they decided to sue you in order for you to be able to win that as a defense. And the second thing to remember for affirmative defenses is that they often will depend on the theory of the case that the other side has used. Common theories that debt collectors use when they sue people are either breach of contract, unjust enrichment, or account stated. And depending on which theory they've chosen, you might have a different set of affirmative defenses you can raise. For example, if they're suing you for unjust enrichment and you can prove that a valid express contract existed, in Florida, that's a complete defense that will defeat the unjust enrichment claim entirely. There are a number of different affirmative defenses that will apply to each type of claim. What those defenses might be are a little bit beyond the scope of this video, but if you do some basic research, you should have a good head start on identifying the list of defenses you might be able to raise. Once you've settled on your affirmative defenses and you've written those up, you're going to want to make the decision about whether or not it makes sense for you to file a counterclaim against the plaintiff in your case. What type of counterclaims might you raise? Well, first of all, there's breach of contract. Did they break the contract before your alleged non-payment? Has the plaintiff somehow committed some kind of credit reporting violation that would violate federal law about credit reporting? Have they committed unfair or deceptive trade practices that violate state law? Or have they engaged in some other kind of illegal conduct like a debt collection violation? One of the most common counterclaims we file is a counterclaim under the FDCPA for some violation of debt collection law that the debt collector has committed. If you don't know whether your debt collector has violated the FDCPA, we have a free email course. I'm going to put a link in the description below. And in that email course, we walk you through the 53 different ways a debt collector can violate the FDCPA that might be a valid basis for you to file a counterclaim against them in your debt collection lawsuit. There's one danger that comes from filing a written response, and that's this. Once your answer is filed, you're telling the court essentially that you're just about ready for trial. We've seen cases where people representing themselves filed a handwritten answer based on a form they got from the clerk, and the day after they filed it, the judge set a trial for 30 days later. because some judges want to fast track these debt collection claims, especially if they see that the defendant doesn't have a lawyer, because they understand that most people without a lawyer aren't going to be able to put up very much of a fight, and they want to get rid of that case as quickly as possible. So before you file your answer, if your case is big enough to be under the regular rules in the state of Florida, you really probably want to talk to a lawyer first so that you can understand the procedural traps you might be stepping in and whether or not you have a valid basis to defend the claim. Now, if you've decided to go ahead and file your answer, you've decided to admit or deny, you've decided what your affirmative defenses are, and you've analyzed your counterclaims, then it's time to put it all together in writing. You're going to want to use the same format as the complaint. You'll want to make sure to use the name of the court, the case number, the name of the case, and then label it as your answer and affirmative defenses. And if you've decided to bring counterclaims, go ahead and mention that too. Now, if you're not sure about the theory of your case, you're not sure what to admit or deny, you're not sure whether you have defenses or counterclaims, I want you to watch the video I'm going to put on screen right now. It's going to walk you through some of the most common defenses to the most commonly raised claims that debt collectors use and how you can use them in order to win your own case. So thank you for watching. I'll see you on the next one.